Inside the program, we get the Public Relations Officer 2, na Judiciary of Salone, Winner Francis Murray. Good morning, sir. Welcome to Radio Democracy.
Good morning. Thanks for having me.
Alright, still inside the studios, Radio Democracy, they expect Alpha Cisse, we are the Deputy Attorney General and Minister of Justice, and same also we expect Charlie Israel Williams, we are legal practitioner, as they come inside the program this morning for we can look at the Criminal Procedure Act of 2024. But firstly, Maury, waiting so far don't they happen na the judiciary?
Well, from them need for no say the judiciary na the third arm of government, where the 1991 Constitution gave the mandate for preside over cases both civil and criminal, and for give justice to whosoever deserve them based on law. And whilst we push forward this way constitutional mandate, we are guided by the principles of impartiality, integrity, and fairness in how we do we work. So, quite of course, listeners they no say. The cadres of we got structure, we get the local court, we get the magistrate court, we get the high court, we get the court of appeal, and we get the Supreme Court, one of the highest courts of the land. Quite recently, a lot to happen, especially under the leadership of the Honorable Acting Chief Justice Nicholas Bramak. We see just last week, we formally opened the September criminal sessions, where the Honorable Acting Chief Justice SSA preside over. And waiting at the need for this High Court criminal sessions. The purpose now for we take the plea of accused persons where don't be committed to the High Court for trial by various magistrates and where they all about the country. And also for consider the one day way the indictment don't be preferred with the consent of a judge in the writing for come for trial at the High Court. So inside this same process, also an accused person plead guilty, the trial judge can proceed and sentence the accused person based on law. But also not plead guilty, he can adjourn the matter to another date to say the accused person will appear before a trial judge proper. So another thing we're very outstanding where we don't do of recent also now for revive the JP's court. We don't come to the realization say with judges and with magistrates them overwhelmed across the country, and so that they to a very large extent result in slow pace at which cases are for the go. So the JPs then are people where they select based on character and integrity in their communities for preside over cases at community level for ensure say them push justice go before. Now when they sit in twos, and when they sit the equivalent to a magistrate sitting, and they deliver the judgment in writing. So if anybody in that community they feel aggrieved by reason of that judgment, then they can appeal to the High Court, where get the power for revisit or even undo or go against that judgment there. And also we don't try for ensure say we move closer to digitization. We get the justice app where don't be developed at the magistrate court, where they ensure say we track the activities of magistrates for ensure say they do the work with them did it for, and with the speed at which we want them for go, then they go by that justice app. They track the reason why a magistrate go in fact adjourn, the purpose of adjournment when the accused person for appear, and the reason why the accused person dey on bail. So then they ensure say we manage with cases at magistrate court level, and for ensure say we dey up to speed. And we also continue with other developmental projects, and we aimed at ensuring say we push this with constitutional mandates go before and forget justice closer to the people.
Radio Democracy 98.1 FM. As you get from one power headline stories today, Radio Democracy go look inside the new Criminal Procedure Act 2024. We repeal and replace the Criminal Procedure Act of 1965 and the impact of this on the justice system in the country. For help we discuss this the program anytime from now, we expect Alpha Cisse, we the Deputy Justice Minister. In the studio now we get Francis Murray, we Public Relations to Judiciary of Salone, and also Charlie Israel William, we legal practitioner. We get for practice under this law. Within the makeup of this, we go come engage them inside the program. But as we wait for the expect for get the justice Deputy Justice Minister at the studio anytime from now. We continue with More from the judiciary as he give updates on the operations of the judiciary. Earlier you begin mention about one thing we don't come with back way na the JP trial system. How this trial system they work and would then go choose a JP and would go choose them.
Well, the JPs, like I said, now people way they of reputable character and stand integrity in the various community society and they are appointed by the His Excellency the President of the Republic of Sierra Leone. Now the Constitution give the mandate for appoint them JPs here, and when they appoint them, and the fact they don't appoint them, not means they can automatically go to the community and begin for work once as JP. Will they come and also try for streamline the activities for ensure so we train them, for let them know them do's and then don'ts. Yes, the president can appoint, but we get with other internal screening mechanisms where they ensure say we train them and let them know exactly what everything they need for do when they go to the communities. Now when they go, then they sit in twos. Each JP's court will sit with 2 JPs equivalent to a magistrate, and then they preside on then half cases that will be overwhelm the magistrate them for some with trials or at magistrate court level. So when they sit, like for instance, them amicus case, then insulting conduct, what have you, then they handle at community level. So the fair not say now the magistrates then they concentrate purely on PIs and also on the summit trials, rather than the half cases will be overwhelmed at that point. But in case anybody feel aggrieved at community level, where then JPs they don't arrive at a verdict or a judgment, you can appeal to the High Court. We get the power for overturn the decision.
Good morning, Salon. Where they come to you live from Radio Democracy 98.1 FM. As we tell you inside the program this morning, we look at the Criminal Procedure Act of 2004. We replace the Act of 1965, and inside the studios we still get Francis Murray, we are the Public Relations Officer too, now the Judiciary of Salon, and same way so we get Charlie Israel Williams, we na legal practitioner, and inside the studios we just joined by the Deputy Minister of Justice, we na Alpha Sise. Good morning, sir. Welcome to Radio Democracy.
Good morning. Thank you.
All right, continue for the way to inside the program, Musa.
Yes, the program Good Morning Salon they continue. As we mentioned earlier, today we look at the Criminal Procedure Act where the President signed this BNTM after we Parliament we don't agree for this law, we mean say it don't repeal and replace the Criminal Procedure Act of 1965. Waiting at the role of this law and how it impact the justice system. Make we get them 3 gentlemen at the studio for come help we discuss. They start with the Deputy Minister of Justice, we Alpha Sise. We lay the basis of the discussions. When we talk about Criminal Procedure Act, what do we talk about now?
Thank you very much, Musa and your colleagues, for the opportunity again for share thoughts with the people of Salon on this very important subject. As we all don't note, Salon don't operate under the Criminal Procedure Act of 1965. That now very long time, 1965. From 1965 to now, a lot of things don't change. Of course, that now some of the laws and when we inherit from the English legal system. So plenty of things don't change. So need definitely been there for update with laws, especially the procedure for criminal practice under this country. The effort for review the Criminal Procedure Act itself don't go on for a long time. Several years ago, various attorneys general done the trial, or various directors of public prosecutions done the trial for review aspects of the Criminal Procedure Act of 1965. We don't get piecemeal amendments over the years. Sometimes those amendments are really wanted by situations. For example, even when we can say the attorney general can make an application for move a matter from a magistrate court right to the High Court on indictment. Not also the Criminal Procedure Act being there, a situation be warrant that we make, they may make that amendment there. So over the years, we don't get piecemeal amendments. So there was a time where legal practitioners actually see the need for like a wholesome review of the act itself. So this process also starts in 2005. The committee actually we then constitute for review the Criminal Procedure Act starts in 2005. So it's been a very long process, So this is an important point. We for conclude that process day. And really bring in a new law where go speak to current situations. The new Criminal Procedure Act, we replaced the 1965 Act, get a lot of innovative things. We can talk about how much time preliminary investigations can take at the magistrate court. Now we try for get rid of PIs, and come with committal proceedings. We will make things faster.
Okay, now, Mr. Alpha, we can look at some of the good things that were inside this 2024 Criminal Procedure Act. But let's take you back. What are some of the wrongs the women did inside the Criminal Procedure Act of 1965, which trigger government for look into and back?
Well, so the 1965 Act really, the way we it been framed, because a lot of delays in the criminal justice system. For example, when say a suspect or an accused person, make an appearance before a magistrate court, we in the context of preliminary investigation, that may take quite some long time, sometimes it will take months, so need being there for short in the time. Sometimes if the magistrate don't determine, say yes, there are basis for proceed to the High Court, it not really puts timing on when the DPP go prepare an indictment, for make the AG sign. So that of course they keep a lot of people in a pre-trial process, we definitely get an impact on the rights of the accused person. And then of course, when the matter go now in a High Court, that time frame, within which the matter will be tried and concluded, you understand, been very elastic, so we get a system where one being the really prolonged criminal trials, and then they get significant impact on the rights of the accused. But also of note is that the 65 Act gets significant impact on even the way we sentence people we don't be convicted. It then gets significant impact on the responsibility where the court gets for make provision for vulnerable witnesses where they participate in criminal trials. So there are some of the lapses or shortcomings where we watch say need day for review. The act itself, and coming with a new legislation where go make provision for very innovative things. We are going to be happy for share thoughts about soon.
The program na Good Morning Salone, the country from the Society for Radio Democracy 98.1 FM, and we will bring you this edition of the program Good Morning Salone. Musa Kamara na my name.
And my name Usman Kamara.
If you just join we today, we look at the new Criminal Procedure Act of 2024 and the impact on the country justice system. We get three gentlemen there at the studio. We don't talk to the Deputy Minister of Justice, Wena Alpha Cisse. He don't mention the Criminal Procedure Act. But now we look at the new acts. What's in the difference with the new acts and the old one in terms of provisions?
Well, you get really fundamental differences. One difference where people will get for see now how we transition from preliminary investigation. We really what we get right now is almost like a two-stage trial process, right? You get process we go on at the magistrate court, and then it goes up to the High Court and everything. So sometimes it causes delays. Now we get a system with the new act. We get a system where they come with committal proceedings. We are in, of course, there's filing of papers. Of course, if the accused person want for cross-examine certain witnesses whose statements have been tendered, then go do that, But then the magistrate gets a particular time frame from the term where a suspect they make an appearance to the term where for determine say this matter they go to High Court is 28 days, and then you get a specific window within which the Attorney General's office for file an indictment within 60 days. You understand? If you not do that, the accused person can ask for be discharged. When the matter appear before a High Court judge, a High Court judge from that initial appearance to detail the matter they done, enough for more than 180 days, so you don't put in then time frame then, we really get forget a positive impact on the criminal justice system. Also, of note is the new act really, they make provision for vulnerable witnesses where they participate in the criminal justice process. It could be say, now somebody way no land book, somebody way blind, somebody like victim of sexual abuse. We need a system where they really make provision for them protection and participation in the criminal justice process. Of course, the new act really adopt in a great deal human rights provisions, within the International Covenant on Civil and Political Rights and the African Charter on Human and People's Rights, all don't be reflected. They make room for, admission of electronically generated evidence or electronic evidence. We in current day, system where we see a lot of evidence where they be tendered na court is electronically generated, and then of course, another important thing is we get now an act where they make room for alternative sentencing. We have a lot of complaints about how we justice system almost kind of like criminalize poverty. You get a lot of poor people, where for certain, minor offenses, they now the prison system. There was a time when I visit the correctional service facility, I see people in the where they na jail for 500 leon, for 1,000 leons, or sometimes, it might be, like some, me brother been the talk just now where JPs, go look at, cases and look for like, mommy cause cases, etc., etc. Right. So now you get a law with the car with alternative sentencing. So not to everybody for really go na jail. That side you keep them for people who really commit serious offenses. You get a law now with the car with alternative sentencing. Go say, okay, somebody go do community service, for certain offenses then we commit. So then one of the things and way the new law they come in, and of course, one thing we will not go run away from, we don't dominate the debate around the act itself. Now that yes, the act gets rid of the jury system.
Yeah, because that's what I know.
That for cows, so make a put on the table.
That's why we wait to my next question. Waiting at the reason we make wanna decide or government decide for police system.
Well, so make not put them on government alone. First, like I say, the Criminal Procedure Act of 2024 don't be a subject of extensive consultations. I talk about almost 20 years. The discussions really for repeal and replace the 65 Act started in 2005. So the jury system don't be debated extensively. And then, of course, this latter part of the consultations will take place. Come up with that again, and then, of course, the thing go parliament. So really, this is something where, everybody don't look at. Take note, say, as part of reviewing this, the 65 Act, also get consultations with magistrates, with judges, we don't be involved. And so, at some point, people come to the realization, say, the jury system, as we don't get them, they operate in a salon, no, they really work for the effective administration of criminal justice. And here's why. First, make we note, say, we really only don't use the jury system for trials. We get capital punishment, death penalty, murder, robbery with aggravation or violence, and treason. For that one, and the law mandates say it will be trial by judge and jury. And then you get other criminal conduct same, right? Even though you see the 65 Act say for trial and by judge and jury, it don't make a mandatory. And so the general practice has actually been that for their other trials, and including those that carry life sentence, trial by judge alone. Okay. But then the one where they carry death sentence, judge and jury, for ensure say a decision on whether somebody for lose in life as a result of criminal conduct not be left in the hands of one person, make it be something where they be determined by what we has called a jury of their peers. And then a couple years ago, this country take a significant step for abolish the death penalty. So now we don't get death penalty anymore, right? For any criminal conduct now, it's either fixed term or life sentence. And then you come out to the challenges we don't get with the jury system. And utmost respect to all the people the man and woman that over the years don't serve as jurors, don't really give them time for help the administration of justice under really difficult circumstances, and some of them it don't be even challenging for make financial provision for them, so it has become expensive to manage. Okay. Sometimes it takes time, right? Because it go prolonged trial, because you get for empanel the jury, right? That takes time. But also it's a situation we are in. Sometimes a trial can go on, and then one juror pass away, one juror sick. Okay. You understand? And once the number go down, you empanel a new jury. Okay. So what does that mean? It means say the suspect or the accused person, you don't prolong in time within the trial. Okay, we can look at more of some of the issues them you talk about. The program na Good Morning Salon, where they come to you live from Radio Democracy 98.1 FM. Musa? The program they continue. We come to we other studio guest. We na Charlie
Israel Williams Esquire. We now a practicing lawyer. We the studio for sharing in your take for SECA, the new Criminal Procedure Act of 2024. Once again, good morning and welcome to the program.
Good morning and thank you.
You are a lawyer, a practicing lawyer. We did represent clients them, different cases them, and we did discuss the Criminal Procedure Act of 2024. We repeal and replace the 1965 Criminal Procedure Act. What do you take on the new law?
Okay, first I need to commend the people that will work around this law. You will see say they really put effort into it. That no means say it's perfect. Of course there is no perfect system, but actually them put the effort together, and what we get now a better past what we been get before. Only that few things and they way, you know, what they try for avoid. Alex say we also they fall into another kind of situation. I mean, I'll give you examples. The review addressed the issue of time. He addressed also the issue of the rights we accused persons can get, and he addressed the issue of autonomy, which power I give to judge or magistrates as the case may be, and privileges. And then one other important thing with criminal procedure and our witnesses, you see say this act make provision that we go deal with all of them things. Baker just touch one fundamental. We constitution say if you investigate somebody for minor offense, I can then have police custody for 2 days. If na serious offense, 10 days. So that time day, in as much as the investigators then be the complain, so especially certain matters and the way we need for investigate, you need time because of the nature of the offense. And so that 10 days we lawyers then can they run after the police then for ensure say then do speedy investigation and charge the matter to court or discharge as the case may be. But now this law don't give provision to the police for going to court, and apply for extension of that time the way somebody in a custody while then they investigate. So you cannot say it's bad, but I mean it don't affect that 10 days we will get as limit. Okay, although the new CPA make provision say the accused person or the suspect can challenge, say no, this extension we don't want, so it will affect me. So it's a kind of, you can't say it's a bad provision, but at least it don't tamper with that time where accused persons then being supposed for spend at police station.
Before this time, now how long they get in a police? 10
days for serious offenses, what you can call felony. If police investigate felony, 10 days therefore don't conclude and send the matter to court. And we lawyers then can make application when it passed that 10 day for let the matter go court. But now the investigators then can apply to court for an extension of that time. So as I say, in as much as we try for make criminal procedure fast, also we don't create this one we therefore be subject to it in the judge think, what he think about the matter. Okay, and then this issue of autonomy, there are times where discretion can be abused. We're not saying when you give discretion to a judge or as a case may be to the Attorney General, means say go abuse them. But we're saying that times where discretion, can be abused. But as I say with regards to the good work where the people that we put, the effort into this, like me what I say from 2005, this issue of committal proceeding. Of course, me as a practicing lawyer, I don't let me client spend long time na magistrate court. They do preliminary investigations, and sometimes, in fact, make help the process for go faster because I don't ask many questions on that cross examination, and I can push for the prosecution carry with witnesses faster. Because sometimes the nature of waiting magistrate they look for under PI, not so much. So for go spend all that time, they some man they do 2 years. We don't see situation where PI they take 2, 3, 4 years safe. So it good for a bridge. And one other good thing with the act create, now that at that committal stage, trial stage, the prosecution they make available documents, statements to the defense. And this now one thing we make within the tape and preliminary investigation. Right. The police get everything then keep up. The day where the witness they come, like the police investigator for testify. Now that day they go carry the accusing statement or the suspecting statement. Now that day go carry so many other things. Where the defense for don't seal all on them, so that the trial will go faster. So that's another good thing. That aspect of making available to the defense all of those statements and stuff. So it's easy for let the magistrate within 28 days or a period, not too far from 28 days, for conclude and say, okay, this matter let go high court or enough it for go high court.
All right. Now, Mr. Williams, one of the key things inside this particular act we everybody concerned, but even though we get a goodies, get for do with the jury system. As a legal practitioner, within a use point in terms of removing the jury system?
Well, legal practitioners themselves can prosecute cases, although that is seldom. Most times we are on the defense. And so when you're on the defense, you really want a situation where it becomes fear for the accused for be tried by not one person but by many. The sense behind the jury system, now this principle where they say it better for free somebody we guilty free him than you convict somebody we innocent and taking life. My brother don't make a good presentation about the death penalty being taken away, but life imprisonment is a serious sentence. It's really serious. When you are sentenced to life, it's serious. So in as much as death penalty is taken away, we for also know say life imprisonment na serious sentencing. And so for me, I think say for remove the jury system, or give the court or the judge the discretion for decide whether this trial should be judge alone or judge and jury or judge and assessor, that for me I get problem with them. Because life imprisonment, although death is away, is now the new death penalty kind of. So I still for appreciate for let the jury system stay. Yes, there are difficulties with the jury system. I agree. There are also difficulties with the judge alone system. Judge self they sick. God forbid, judge self they die. And we get a situation where judge they also can absent from court. So no system not the way perfect, as I say. No system. And for me, I think say it not serve the accused person right, especially while they face serious offense we go lead them to life imprisonment for take away the jury system. That is my honest opinion.
Okay, continue for inside the program. Charlie Israel Williams, in a legal practitioner. We'll come over to you, Francis. Now, una na the powerhouse wherein now una they give justice and look inside different cases. What do you think about the new act of the criminal procedure?
Well, like my other two brothers don't say, you get your own gains, you get your own pitfalls, but basically we didn't at the receiving end. Yes, we didn't at the receiving end. Every other activity around the act get for come back to it because we mandate now for interpret the law and punish lawbreakers. So with the state charge a lawyer get for come before we for defend the accused person, the state get for them before we for ensure say a prosecute the matter in the interest of justice. But also we really come in as an independent arbiter of justice now. For let we embrace the gains that we don't highlight in this new act. Over the years, they don't lash with society, don't lash with on delay of cases. So the judiciary they waste time with cases. One case go in a court for a very long time. Now you don't hear from the deputy minister that they make some arrangements for eliminate PI and replace it with something we go ensure say cases go faster. Before now, the magistrate in responsibility now being twofold for ensure say one, they do preliminary investigation, so we call judicial investigation, for see if the matter we did before when a felonious matter meet the prosecutorial threshold for be committed to the High Court for trial. Now once he don't ascertain that he committed, so now the speed at which this act don't bring for let matters the follow up at the magistrate court go ahead for vindicatory, because they not be they understand the intricacies of what they deal with as an institution for ensure say cases and move. The number of magistrates across the country limited, even judges, so that it eliminate them at that point go bring relief to we and for let magistrate and now concentrate proper on summary offenses who side and get mandate for trial and adjudicate the and sentence as where the evidence leads. But also this tropical issue of bail, like when the deputy minister say, now more than ever before it has been reformed over and again for let the judicial workers, the judicial staff know say bail now of right, not to privilege the accused person for enjoy. And going forward, special needs therefore be taken into consideration of the accused person for ensure say they admit them to bail. If, for instance, the accused person a pregnant woman, a lactating mother, or seriously sick, these are considerations now where the judge they really take key and integral for ensure that this accused person be admitted to bail for ensure that he can accord. When in fact the reason we make then they admit accused persons to bail. But when it comes to the area of sentencing, we don't get a flexible system like the minister say. We really get for work for we, because part of what we they do now the prisons court initiative now for depopulate the correctional center and for ensure say we reduce that workload on government for take care of convicts at that point. The budgetary allocation be heavy. Some of magistrates can be just the sentence and commit people in prisons for minor offenses or alternatives for day. So this act coming into play, they make provision for community service. We say an accused person who has been found guilty, for instance, can 98 for work, prison authorities can release and can say do community service. Whilst in the do una say go to get a small thing way that fund will go to the community for ensure say it help other thing for go before. And also we get suspended sentence. Suspended sentence now like a way an accused person will go before the court, then try them, then convict them, but you know they go jail. If they work out with that sentence on your head and they monitor you, should you commit if like they don't sentence for 4 years? That sentence they with you they pass with it. Nobody know they convict, nobody know they disturb you. But should you commit a similar offense and come before the court now they try you without a premium on that previous offense. But if they convict you, like now 1 year be done left for let you serve that sentence, then they consider this one will be there outside for and this new one and they put them together for sentence you. Because now for depopulate the correctional center. Now we get to go deferred sentence. Deferred sentence now way the court now for the look into instances where people where now convicted persons, if na primary caregiver, na mama, na papa, much of what we struggle with as a society now, existential problem, the decline of parental care. So if an accused person is a primary caregiver, when I don't convict them, the first sentence they give the court the liberty to the liberty to the judge for say, okay, we don't convict you, Mr. XYZ. You a primary caregiver, you get 3 people under you. Go put your house in order. Go ensure say this person deal with this uncle, this pikin deal with this auntie, this day to this sister. For ensure say when you the service sentence, they no go there about the smoke kush or what have you, no go astray. So this is not the laxity we don't get for ensure say we uphold human rights. For ensure say even the accused person or convict get that kind right for service sentence in a peaceful atmosphere.
The program is still listening to now. Good morning, Saloon, where they come to you from the Society for Radio Democracy 98.1 FM, and we will bring you this edition of the program. Musa Kamara and my
name Usman Kamara.
If you just join we today, we look at the new Criminal Procedure Act of 2024 and the impact on the justice system. We get the Deputy Minister of Justice, we Alpha Cisse. We get a practicing lawyer. We they with we the studio, they share your own experience about them. We Charlie Israel Williams Esquire, and also we get More from the Judiciary of Salon from the Public Relations Department. We continue for look at more issues for SECA, the focus of discussion today. We go inside the Center for Accountability and the Rule of Law, CAL. Now, them UNDP be in support for be secretary to the committee. We be look inside this act. Ibrahim Tomin, the executive director, they say Salon people for use the Criminal Procedure Act 2024 for help the justice system forget the integrity back where people expect and forget and start forget trust in the judiciary of Salon. Well, we talk more to Michael Sambola inside this interview.
We done the try for pass that law from 2005, so it take nearly 18 years or more than 18 years for complete that process. So it is really a huge one. Now, waiting at the sort of spirit, the driving force, waiting influence the review. First, the law don't change now. Way back in 1965, and times don't change. We did now in a country where we get the 1991 Constitution, even though we don't try for change our Constitution self for a very long time. If you get law when they make in 1965, you get the 1991 Constitution. A lot don't happen or don't change. We necessitate that review. So we get a number of issues then. We get for deal with sentencing, preliminary investigation, the time when they take for let magistrate they investigate serious offenses before they commit them to high court for trial, or before they decide say case not day. We also get the whole issue of protecting civil liberty, where police arrest and detain person before that person they come before a judge or a magistrate. We think it happen. We know say plenty time police go keep the person for more than 3 days in case of minor offenses, even though the Constitution talks it for be just 3 days. And then for serious offenses, the Constitution say 10 days, but the police can keep them more than 10 days. And they not can come back in a court say for seek any order from the court for me to continue for detaining people in there. Then the issue of the jury. We get a system. And we still get the system because even though the president does sign the law, they will not be used and made because the Minister of Justice still need for take one step at least before we begin use them. So the jury system we don't talk say it account for most of the delay in serious criminal offenses. So there was a huge discussion about whether for keep them or for remove them. Then sentencing. Right now, only 2 forms of sentencing. Either you find person or you send them go jail. Sometimes the magistrate can bind you over the piece.
The scholar them, we also some past active lawyer them also been continue by the debate, and also civil society organization we then think say the criminal justice system na Salon could become fair and just if the jury system did. Then think say if one man, the judge, will rest all thing in hand just for take decision, it mean to say still it could be unfair.
Whether you get a trial by jury of 20 or 24 jurors or 54 jurors, you know, they guarantee fair trial unless those jurors are persons of integrity. Because if you not get integrity, like you put 1,000 man them on a jury, they go still act dishonorably and not deliver justice. What we need in a judicial system now, primarily men and women, judges, magistrates, court staff, police officers, correctional service officers. These are the people we need for act with integrity and honesty, with regard, high regard for deliver justice. if you not get that one day, jury system not they save you. Let me tell you why. Because what people and they say is, if you get one grand judge, they go act one way or the other against the interest of justice. So what are the safeguards? The safeguard are that if the judge deliver a judgment we think is patently unfair or unjust, you go now Court of Appeal. Court of Appeal acts, agree, you go Supreme Court. Similarly, if really people, because most times people in the field say, the states go influence the judge.
Yes, now they come in terms of the faith where the people then get into the justice system and the kind way how the justice system don't perform over the years, don't make people then don't lose faith. And many people think say because government they appoint the judges, they get control over them.
No, clearly the issue about confidence or lack thereof in the justice system now still a major challenge. Even the acting chief justice could be the first person to tell you, say yes, the judiciary need to do a bit more for increase that confidence. And that lack of confidence or perception of lack of confidence not only they exist because of the jury system, perhaps partly because of the jury system. Where possibly can a court they wait for the judgment of the court. Trial where the express could last for 1, 2, 3 months. It takes 6 years. The magistrate grants bail or the judge grants bail. The process for them, they actually release that person now from custody. It takes forever. It require them for do more. They lose confidence in the justice system.
The program Good Morning Salon, where they come to you from the Society for Radio Democracy 98.1 FM. You will be listening to the Executive Director for Center for Accountability and the Rule of Law, Ibrahim Tommy, as they get a own take on the new Criminal Procedure Act of 2024. We still get to the studio guests, then we come to the Deputy Minister of Justice. You don't get from the other side, then you don't get Ibrahim Tommy in take on the Criminal Procedure Act of 2024. Let me look at the popularization of this act, because plenty just there the Criminal Procedure Act of 2024, the jury system now unpopular among them. What will they do as ministry for popularizing?
Well, so we make sure say a communications plan accompany the rollout of this legislation. Yeah, so we already in discussions, one internally, as a ministry, as well as with the judiciary and the Ministry of Information and civil society partners, for me to really raise awareness, because I go back to my days na Afrobe College where I've been there as president of Human Rights Clinic. The thing where we've been very known for saying now that they able to claim your rights if you don't know their rights in there. So this not only for magistrates or judges or police or correctional service or lawyers. We want the public know within the inside this legislation. Yeah, so now that way they then go able for really benefit and own this process. And one thing I want to add, as part of the public knowing, I'm glad the way my brother Ibrahim Tommy talk about safeguards, the appeals process. But also of note, even though the new act, the get rid of the jury system, whilst not say like for like, but another safeguard, now that you get the assessor system, wherein for certain matters then, whether based on application from the state or even the accused person, a judge can handle a matter with the help of assessors. Certain countries then get different kinds of assessors. It can be lay assessors, some it can be experts. And what in this mean? Musameka just breaking down. Now, a lot of the time, when they get complex evidence, when we talk about electronically generated evidence, we talk about financial transactions we get for with evidence. Sometimes some of them things also might be strange for even the judge. But when you bring in assessors, when are people and we get expertise in their areas, then they sit down with the judge, then provide guidance to the judge. At the end of the day, of course, the judge takes the decision, but they are able to state their opinion and provide that guidance to the judge. So this is in the act, so I just want to make people.
So when this act they come to force?
So we did in discussions. So on getting a specific date. Now it happens, say, Parliament Day in recess, because the commencement date actually states, say the date will be set by the Attorney General by statutory instruments. And when you table statutory instruments and Parliament, you need 21 days for make it mature. So we use this time also discuss with the judiciary, give this window for make we really prepare, for all this.
But we don't see already in Abdul Bakar case, the judge, they ask the lawyers then for go study the Criminal Procedure Act ahead of the new adjournment dates. Why is it like that?
But of course they have to. It's new law. It's procedural law. You understand? It's not a substantive offense law, right? So a lot of confusion on the whether you can transition a criminal trial. If this new act comes into force, it's procedural law. You understand? It comes with new procedure. So as a lawyer, you get for study, because it might be say whether not for this case or some other case, this is what you're going to be dealing with, or it might be say in the middle of the case, some procedural issues change. So as it is, like I say, the judge, of course, sets an adjournment date. What happens, when the trial resumes, that will be determined by the judge, But yes, he is right. Forget the lawyers then for go study the act, because it might just be used during the conduct of the trial itself.
All right, continue for the way to inside the program. We'll come over to you, Mr. Williams. What do you hope for see this time around?
Yes, before I touch that, what we hope for see. The act, now the last provision, the last section, it say if you already take play under the old law, well, I don't want to call it old law, under the 1965 Criminal Procedure Act, then you'd have to continue with that. So I think say we need for take time for look at that issue they properly, so that we not get a procedural breach and maybe create situations for appeal, grounds of appeal and all of that. Because the law they say if you have started, you would have to continue. So I'm sure that's an issue, for look at again, for ensure say we know conflict the situations. I think say what me they look up to, just as Brother Tommy say, there is no perfect system. Judge alone, judge and assessors. In fact, make a comment on assessors a bit. Unlike the issue of jurors, where now then they make the decision, the judge they guide them, because they're not sabi law. With the assessors, the judge is not bound to go by what they say, their suggestions or their opinion. The judge is not bound. And if he does not follow what they say, you can't take it against the judge. So we therefore also clearly state that one. Say the judge not bound for go by what the assessors they say. Okay. So what me they look up to now a situation where we go try for popularize this act. Okay. We go do them as fast as we can. The lawyers already they under training. They would have to learn it their own way, or maybe the provision where the ministry go make, or even with court, because the judiciary, I must say, nowadays the judiciary is very proactive, and we see the steps they willing to take. Okay. So we hope say we go able to get a playing ground. We go make everybody understand what in this whole thing they're about. And how, because normally when a law is new, the interpretation and how to adjust and all can create some issues. Okay. Like we limit the magistrate now, so you get 28 days for ensure say this matter, you determine whether I for go high court or not. You get for now things say almost case day before this magistrate, where you put all them 28 days then they together and other matters than they. But the good thing, the JPs themselves they now. So no, not just give time, and then we create a bottleneck. At the end of the day, the magistrates get a lot of case for deal with, a lot of committal proceedings, and then he still get for work within 28 days. And we lawyers are waiting with good pan now for make applications. Okay.
Over to you, Deputy. See your response.
I just want to come from my brother in last point. Say, so the rollout of this legislation, it's not done in isolation.
Yeah.
This now part of a broader effort for reform the justice sector. So after this, of course, several other laws then will be reviewed, some will be repealed and replaced. But also, within the context of we effort for reform the justice sector, we definitely want for make sure say we not overburden the magistrates. And so that is why, my brother talk about certain cases and we go to JPs. We also did discussions on enacting a mediation law. So certain disputes, and they, of course, right now the focus is on civil, but we learn from some other countries, and we even in the context of criminal conduct,